So this statement is read on behalf of the Law Society of Kenya, the Police Reforms Working Group, at an alliance of 21 human rights organizations, including Amnesty International Kenya and Vocal Africa, who are here present. The Police Reforms Working Group, the Law Society of Kenya, and Vocal Africa are deeply concerned by the arbitrary arrest and continued detention of Kenyan activist Mwabili Mwagodi. According to the information already in the public domain, he was blocked from lawfully exiting the country at Lunga Lunga while he was traveling to meet his former employers in Dar es Salaam. Neither the immigration authorities nor the Directorate of Criminal Investigations have yet provided public clarity on the legal basis for the arrest. We do not have a warrant of arrest with charges. What we have essentially is orders for investigations. This afternoon, there was a spirited attempt by the defense lawyers to allow him to basically return to his family. He has been cooperating since his arrest on Sunday, not Monday. So as of the next 2 hours, he probably has been in detention, pre-trial detention, for 48 hours. The circumstances of this detention raises serious concerns about the violation of his constitutional rights, including the right to liberty, due process, freedom of movement, and protection for arbitrary arrest. We are noticing two trends that we are deeply concerned about. The first trend is the trend of the Director of Criminal Investigations to essentially seek pre-trial detention orders. This means that they want people to be incarcerated, detained, while they gather evidence. And obviously, under the Constitution, under our laws, one is placed under arrest once there is evidence that you have broken a law. So this pre-detention trial, or the pre-trial detention, is a matter of major concern. The second trend that I think we have to look more closely at and to demand from the government more clarity is the use of red notices. The use of red notices, as provided for under the Interpol regime, essentially provides for serious criminals and serious criminal offences to be investigated. And this does not actually constitute a case when it comes to political speech or political activism. And therefore, we are concerned that the Kenyan authorities are now misusing international police mechanisms to essentially intimidate and to follow people who are extending their rights to free expression and political preference. We therefore are calling for the following. The first is that the authorities must publicly clarify the nature of the alleged offense. They must provide documentation that supports the claimed red notice. The ongoing detention without charge and explanation for more than 48 hours now, we consider as unlawful and a violation of our laws. We continue to request that the suspect, as he is now placed under, Mwabili, be given consistent access to legal counsel, his family, and medical care where required. We will be continuing to focus on the issue of the use of the red notice, and we will continue to follow this case in the courts to establish whether the red notice has been based on a valid judicial warrant and explicit charges. The use of an unclear, undisclosed alert that is not even communicated to Mwabili risks the abuse of process. Thank you very much.